Orleans Humanist Perspective, presented by the New Orleans Secular Humanist Association, following our few principles of humanism.
We're committed to the use of science and reason for understanding the universe and for solving human problems. We're skeptical of untested claims of knowledge, but we're open to new ideas.
We are concerned with securing justice and fairness in society and in ending intolerance and discrimination. We are committed to the total separation of religion and government.
We affirm humanism as a realistic alternative to the theologies of despair and the ideologies of violence. We reject the concept of an afterlife and believe in living a full and rewarding life here and now.
We value and respect each individual's right to judge and lead their lives according to their own position, as long as it's respectful of other people, living in a free society.
We hope you enjoy today's program and others in the weeks to follow. Hello again. Most of you know I'm Harry Greenberger, host for this show, and today I have a very special guest, Mr. Michael Mitchell. And Michael is a long-term neighbor and friend of mine. He has been a practicing attorney in the city of New Orleans for over 30 years and specializing in employment and labor law. And along those lines, we're going to talk about religion in the workplace. But Michael, before we do that, there's another aspect of your activity that I'd just like us to talk about briefly, and that is your involvement with theater in New Orleans. I know that you have spent many years on the board of directors of Le Petit Theater and the Vieux Carré, which has had a renaissance and is now back up and operating. But you're also the president of the New Orleans Theater Association. Tell us something about those things.
I'd be happy to. Thank you for asking. The New Orleans Theater Association, the acronym is NOTA, is the local presenter of the Broadway series at the Sanger Theater. We don't produce the shows or anything like that, but we make sure that the local contracts are signed and that things go well. And in exchange for that, we receive a portion of the tickets, of the ticket price. And we're a 501c3 organization. We're completely charitable. We use 100% of the income that we get from those Broadway shows to support the arts.
They don't pay you a big salary as the president?
No, not a bit. The entire board is all volunteers.
Okay.
But we make donations to local schools, local theatrical productions, local musicians. It's very satisfying work.
All right, but was it your organization that was bringing those same shows to the Mahalia Jackson before the opening of the
Yes,
Sanger?
That's exactly right. We've been around for quite a while. NOTA was formed in the 80s. Originally was called the Civic Light Opera, and we changed our name to New Orleans Theater Association. And since then, we have made donations large and small to a wide variety of organizations. We'll do something as small, for example, as buying a tuba for a high school band that needs a tuba, or something as large as making a substantial donation to the University of New Orleans to help fund an endowed professorship, which will bring in an artist in residence every year.
I see. Well, considering the capacity of Mahalia Jackson and the capacity of the Sanger, I would have to guess that whatever small percentage your group gets, it still is a substantial sum of money.
It is indeed, partly because the response of the public has been so great to the performances at the Sanger.
Incredible what large audiences they've been getting. Let me say this, I recently attended a performance at the Sanger, and that theater is gorgeous.
Isn't it?
It is my opinion that it may be the most beautiful theater in the country at this time, because everything was restored, the statuary, the murals, it is really a beautiful venue.
It was a lot of work, a lot of time and effort, and obviously money went into it, but a lot of thought as well. And I think they've done a spectacular job of restoring that.
I would agree. Now, let's talk about religion in the workplace.
All right.
What can you tell us about where that stands, where we stand, where it's going? Tell us about that.
I'd be happy to. The concept of religion in the workplace is protected under a particular federal law. It's Title VII of the Civil Rights Act of 1964. And a lot of younger folks who may be listening to this will find it hard to believe that prior to the enactment of Title VII, it was perfectly okay to discriminate, for an employer to say, well, I've got these two applicants here, one is black, one is white, I'll choose the white just because I don't want blacks working for me. And that was okay. That was considered lawful. It didn't violate any law.
Up until the year
1964.
Okay.
It was after Kennedy's assassination. One of the first things that Lyndon Johnson first major pieces that he was able to get passed. Well, what Title VII does is it establishes certain protected categories, and those categories are race, sex, religion, and national origin. Now, later laws, there are separate laws that add age discrimination or disability discrimination, but that's beyond our conversation here this morning. So just focusing on Title VII, what it does for an employer is say that you may use any legitimate business reason that you care to make an employment decision, who you hire, who you fire, who you promote, who gets the office in the corner. And those are all employment decisions that you can make on any basis you want, other than the person's race or sex or religion or national origin. So focusing on just the religion part of that, there is a little bit different approach to the protection that is afforded someone for religious beliefs. Because when it comes to race and sex and national origin, the only requirement is that the employer refrain from doing something, that you not use race, for example, as a basis for a decision. But with religion, it's different. You have to refrain from using religion as the basis for one of your decisions. But in addition, you have an affirmative obligation to try and accommodate the religious beliefs of your employees.
After they've been employed. But if there are two applicants, and of course we're talking about private industry as opposed to government.
Absolutely.
If there are two applicants and one is a Jew and one is a Christian, what restrictions are there in making that decision which one to hire?
That decision has to be made exclusive of the religion of either applicant.
On the qualifications?
Qualifications only. Again, any legitimate business qualification, one may have more education, one may have more experience, one may have a more outgoing personality, and it's the type of job where you meet the public. All sorts of legitimate reasons to favor one person over another, but it can't be what their religious beliefs are.
All right. Unless, let me ask you this. Let's say it's I think the Archdiocese has or had a TV station. Mm-hmm. Could they prefer Catholics to employ, or were they subject to this same restriction?
Real good question, because there is an exception. There is a ministerial exception and a religious institution exception. If you are a religious body like the Catholic Diocese, and you are operating something with a religious mission, such as a school that you want to inculcate the students with Catholic dogma, mm-hmm. You are allowed to favor and, in fact, exclusively hire those people who subscribe to your beliefs. Not necessarily to be a Catholic, but to believe in Catholic principles. And if you have a choice between someone who does and does not, I'll give you a specific example. There was a case where a woman was a teacher in a Catholic school, and she was unmarried and became pregnant and was fired for it. She sued and lost, and the reason that she lost was because it was a religious institution, and part of the beliefs that she was supposed to ascribe to is that you don't have children out of wedlock. Well, since she didn't follow their beliefs, she couldn't continue to work in a religious institution.
Even though that may have been an accidental pregnancy?
Accidental,
it didn't matter.
Conscious, did not matter.
Now, I don't want to get us too far off the subject, but if that same Catholic school receives some public funds in the way of vouchers, for instance, in Louisiana, how does that affect their obligation as to discrimination?
It really doesn't. What affects it is, does the institution have a religious mission or not? I'll give you a different example. Let's say a church also runs a daycare center. The daycare center doesn't have any religious aspects to it. It's just a daycare center. And anybody can go to it that they want to, and the children are entertained or something, but they're not indoctrinated in any way. That's different. You do not, that church would not have the exemption that we just talked about, because there's no religious mission there. There's a similar, it's called a ministerial exception, and it's really kind of common sense. If you're hiring someone to be a part of the clergy of your denomination, obviously you have the right to limit your hiring only to someone who is an ordained minister in your particular group.
Well, now, when you're talking about non-discrimination on a religious basis, what about atheists?
Atheists are also included in this protection. It protects those who have any particular religious belief or no belief. And the mere fact that you espouse no belief in religion makes you fall into this protected category. And I know that some secular humanists get prickly, I'll say, if you refer to humanism as a religion, or if you refer to atheism as a religion.
Well, of course, by definition, atheism means no religion.
Right. Well, the way this law that we're talking about works is it protects you if you espouse a religion or if you espouse no religion. It doesn't just protect theists. It also protects atheists.
All right. Now, this matter, and you're an attorney, this matter of protection of religion in the workplace, is that a major, anything of major import? Is there a lot of concern about that?
There is actually less so than those other categories. It's far more common for me to defend an employer, and that's all I do is defend. I defend employers who are accused of violating this law. And it's far more common to have a case of sex discrimination or sexual harassment or race discrimination. Religion and national origin are less common, less typical, but that doesn't mean that they're not there. And in fact, statistically speaking, I just read about this the other day, incidents of religious discrimination or cases of religious discrimination are on the rise.
On the rise because of probably those very ultra right-wing Tea Party people. In fact, in this country, it's very strange. In Europe, religion is disappearing. In this country, it's getting more dominant, and more dominant by the extreme right-wing people. Does that account for why more of these cases are coming up?
I don't know. I wouldn't venture a guess as to whether or not a move towards conservatism has anything to do with it. I can tell you this. There was definitely a spike in religious discrimination claims and national origin discrimination claims after 9/11, mostly brought by Muslims. They were either being discriminated against at a higher rate, or they certainly perceived that they were being discriminated against. And those claims definitely spiked. That tailed off a little bit, but recently it has begun to rise.
All right. Do you have some cases, some instances that might be of interest in this respect?
Sure. There are situations where employees want to proselytize at work. There are some religions, evangelical Christianity, for example, where a tenet of the belief is that you must try to save souls and you must reach out and try to convert people and so on. Well, an employee has a right to do that at work, but an employee does not have a right to harass a fellow employee. Same thing with an employer. An employer has certain rights and can be a believer, a devout believer, and say to the public, my business is a Christian business. I've seen several clients who in their newsletter, in their employee newsletter, will include Bible quotes, or some will even go so far as to have a chaplain on staff to do counseling and human resources types relations. And that's permissible. That's okay, so long as the law itself isn't violated. If this Christian employer, we'll use that as an example, it could be anything, but if this Christian employer says, I'm such a devout believer, I will not hire anyone who is not also a Christian, well, that violates the law, and you can't say that.
But you never know when they might be doing it without saying it.
Well, yes, facts are always a problem. You have to be able to prove your case. But to give you a specific example, there was a woman who worked in a bank, and she was an atheist. She was required to attend weekly staff meetings. And the staff meetings, 95% of the staff meeting was on business-related subjects that were of importance to the people who were in attendance. But the meetings began with a prayer, and sometimes they began with a short devotional, and sometimes it was the owner of the company, or the president of the bank, who was conducting the devotional. Other times it would be some outside clergyman, usually a Protestant Christian. The woman was an atheist, and it made her distinctly uncomfortable. She stopped going, and for a while nobody noticed that she wasn't there, and then it dawned on somebody, well, Sally isn't coming to the meetings anymore. Her supervisor spoke to her and said, this is mandatory, you must go. And her response was, well, I'd like to go, but I'm so uncomfortable with the devotional that I would rather not hear that. His response was, well, just sit there and close your ears. Well, that wasn't acceptable to her, and ultimately she quit and sued. He tried to defend himself, the company tried to defend itself by saying, well, she voluntarily resigned. But there's this concept called constructive discharge. And what that means is you make it so unpleasant for someone that they have no choice but to quit. Okay. That's not a voluntary resignation. That's a firing. Okay. So she was fired, it was for a religious reason. It was because she didn't want to attend these the 5 minutes of the meeting that was limited to devotionals, and she won.
I assume it was not you defending the employer.
No, it was not. That's just a famous case that's out there. But she should have won. She should have won because. Let me back up to one of the things I said earlier. What the law requires is that if an employee has a religious belief, or in this case, a non-religious belief, an atheistic belief, the employer must reasonably accommodate that belief or non-belief. And a reasonable accommodation is something that does not cost a lot of money. An easy example would be if someone says to the boss, I can't work on Saturday because it interferes with my golf game. The boss has every right to say, you will work on Saturday or I'll find someone else. No problem. But if the person says, I can't work on Saturday because that's the Sabbath and I'm not allowed to, the boss can't automatically say, well, you either work or else. What the boss has to do in a situation like that is to say, well, let me see if I can accommodate you without materially harming my company. If I can get someone else to voluntarily swap shifts with you, if I can bring somebody else in and change your schedule to where you work on some other day, that's a reasonable thing to do, and the law requires you to do that. On the other hand, if the only way to accommodate that employee who wants Saturday off is to bring somebody in on overtime or to hire a temp or something like that, that costs money, and that's not reasonable. So getting back to the atheist who didn't want to go to these meetings, a reasonable accommodation would be sit outside for the first 5 minutes of the meeting. And when we're done with the praying and the devotional, we'll let you know, and you come in for the business part. That would have been reasonable.
That would not have been discrimination, which would have made her stand out as, as not a part of the group, and that would not be considered harmful to her.
No, I don't think so. And I'll tell you why. There has to be a little bit of compromise on these things. One of the good things about this law, and it is a good law. I've spent my whole life defending against people sometimes who were accused very falsely by people who misuse this law. But that said, it's a good thing. It's one of the better laws that we have. But one of the good things about it is it requires compromise. Because let's take your example. If she said, no, I don't want to sit outside the meeting for 5 minutes because I would be the only one, I'd be isolated, it would make me feel awkward. Well, about the only other thing to do then would be to say, there will be no opening prayer, there will be no devotional, and that sort of infringes on the right of the employer, who, after all, is also protected by this law and has a right to espouse his religion. So it's sort of a trade-off. I'll give you a similar example of trade-offs. That's where someone is proselytized at work by a coworker, and he or she takes umbrage at that, is annoyed by that, is irritated by that. That's not sufficient to rise to the level of harassment. This law protects race, sex, religion, and national origin, and so you can't discriminate on the basis of, let's say, race, to take it out of this context just briefly. You can't discriminate on the basis of race in hiring. Once you have a minority employee, you can't then allow people to harass that person so badly that it becomes a hostile environment. Sexual harassment is the one most people are familiar with. But there is religious harassment as well. Now, if every time the boss passes by an atheist's cubicle and says, "You're going to hell and I know it. You better come to church with me. You better get right with God."
That's harassment.
Yes, because at some point, maybe not once, maybe not twice, but at some point, that's going to rise to the level where the person who is listening to it becomes so frustrated, so tied up in knots that they no longer want to come to work, or they can no longer do their job, they can no longer concentrate. A hostile environment has been created. But compare that to a coworker who says, "Harry, come to church with me." And you say, "No, leave me alone. I don't choose to do that." That may annoy you, but an annoyance is not a cause of action. You can't go into court and say, "Your Honor, he hurt my feelings," or "she irritates me." There's a famous line from a Supreme Court case talking about Title VII that says, Title VII is not a civility code. You can't make people be nice to each other at work. It would be nice if they were, and it's good employee relations if they are.
Yes.
And employers should certainly encourage people to be nice to each other. But you can't force it, and you can't make people like each other. It's a tough world out there, and when you go out to work and you join the workforce, you run the risk of getting your feelings hurt. You run the risk of getting annoyed and getting irritated. And you have to kind of put up with that. What you don't have to put up with is harassment that is so pervasive and so strong that it changes your job requirements. It makes your work environment different than everybody else's.
I want to thank you so much for coming over and talking to us.
It's my pleasure.
I want to thank you folks for being here today, watching our show, and we hope we'll see you here very frequently.